the rules of parking were not followed. People would park in any direction, would park on sidewalks in a very pedestrian area. If you know the Byward Market, it's small businesses, storefronts. It's really clear where you're supposed to park and where is the pedestrian realm. So the surge of vehicles, pickups is one of the aspects, and we saw that in different areas of my community. The Bikers Church in Vanier was one area. De La Salle High School was another one.
Wait for the punchline.
Along Rideau Street and the Byward Market were other areas. Nicholas were others. So there's those incidents of people not following the rules of the road.
Parking rules.
Pickup trucks, which is a different vehicle, which is a weapon in itself. But the weaponized description to me is really the rigs who take space on the street. The rules of parking.
Pickup trucks, which are a weapon in themselves. And you'll notice some interesting echoing of some of Justin Trudeau's prior rhetoric, taking up space, taking up place. Good evening, everybody. This is a highlight from day 2 of Canada's Emergencies Act inquiry, whatever they're calling it, the public inquiry into whether or not Justin Trudeau, not whether or not he should have invoked the Emergencies Act, just the legislative requirement that they explore, for the sake of transparency, the circumstances surrounding Justin Trudeau's invocation of the nuclear weapon of Canadian legislation, the Emergencies Act, the substitute, the replacement for the War Measures Act. This is, what's his name? Mathieu Fleury. He's a city councillor for Ottawa. His testimony as to why it was necessary that Justin Trudeau invoked the nuclear option of Canadian legislation to suppress this protest as a national emergency. I didn't hear too good. What did you say, Mathieu?
The rules of parking were not followed.
I'm sorry. Can you say that again?
The rules of parking were not followed.
One more time.
The rules of parking were not followed.
The rules of parking were not followed. There were pickup trucks parked everywhere, and pickup trucks are a weapon.
Rideau Street and the Byward Market were other areas. Nicholas were others. So there's those incidents of people not following the rules of the road in pickup trucks, which is a different vehicle, which is a weapon in itself. But the weaponized weapon in itself, which is a weapon in itself, which is a weapon in itself, which is a weapon in itself, weapon in itself, weapon in itself. But the weaponized description to me is really the rigs who take space on the
they take space. They take space. How ironic that this government official, city councillor Mathieu Fleury, spouting off some of the very same rhetoric, referring to vehicles the way Justin Trudeau referred to Canadians. It's ironic, or it's trickle-down nastiness. But it is telling that this man refers to objects the way Justin Trudeau referred to Canadians. They take up space. They take up space. Should we tolerate these trucks parked on the sidewalk? Should we tolerate these Canadians? This witness on day 2 testified to the fact that cars were not legally parked. Bring in the military. By the way, I got to show you this because the woman sitting next to him, Catherine McKinney, she's the other city councillor who testified the other day. She had some doozies of some testimony. Let's just get one of them. Oh, here we go. This is Catherine McKinney telling the other witness, Mathieu Fleury, to answer in French. Pretend you don't understand English now, and answer in French because you know the guy cross-examining you doesn't speak a lick of French, and he's going to have the headphones for the real-time translation. But let's just get one of the sound bites from Catherine McKinney, city councillor for Somerset, Ontario, elected official, and then we're going to get to the punchline.
And in terms of any kind of threats to safety, unruly behavior, was any of that type of personal safety issues reported to you? and or did you witness any of that yourself? Councillor McKenney?
I didn't personally witness any acts of violence. I was
Scrap it. End it there. I didn't personally witness any, but I got a whole lot of secondhand hearsay. Okay, this is funny. Someone said in the chat, who's the person passing out? Someone passed out, allegedly skydiving, and then wakes up. Anyhow, that's not what I wanted to show you. What I wanted to show you was Catherine McKinney, city councillor. I guess I gave her too hard of a time by clipping her testimony and sharing it with more people than I guess she wanted people to see. Catherine McKinney, city councillor for Ottawa, blocked me on Twitter. There should be a rule that if you're an elected official, you can't block people, but it doesn't matter. I was sharing her testimony, not so that she would know that I was watching it, so that everybody out there who doesn't have an entire day to watch these hearings should hear them. And I guess Catherine McKinney, I didn't call her any names. I might have called her a liar. I think adults can deal with that. But she blocked me because I guess she did not like that big, shiny spotlight to make everyone understand the absurdity of what we are currently witnessing. Good evening, everybody. Sunday night, I'm wearing a Salty Army shirt that he gave me. Sent it to him. It's very, very comfortable. I have not yet had anyone on the street, like, hey, you what? You're Salty Army too. It'll happen one day. David, why are you not testifying? So I take for granted everybody watching tonight watched yesterday's stream, but maybe there's a lot of people who didn't. The public inquiry into the Emergencies Act, it's going on now. It's going to be 6 weeks of witness testimony. I don't know why I'm not testifying. I didn't sign up. I'm down in Florida now for, at least a couple of years. I didn't sign up. I would happily testify. I'm trying to message a few people to see if I can go down there and testify because I'd have some stuff to say. But we'll see. I don't know if they have any of my documented footage lined up for witnesses, but we'll see if I can squeeze in and maybe fly down for a day or two and testify. But I just didn't. You think I'm afraid to testify? I hope that's a joke. Yeah, I'm afraid to testify. Yeah, that's okay. That has to be a joke, so I'm not going to take it seriously. Good one. Yeah, I'm afraid to testify. I doxed myself for having donated $1,000 to the convoy before anybody doxed anybody. And if anybody thinks it's more dangerous to testify there than it is to share my mind day in and day out, like I've been doing for the last however long, you have to have a problematic assessment of risk and life. So it is. We'll see. It's just I've been down here and it hasn't been. Testify for what, Viva? They are having the Emergencies Act inquiry, and they're calling witnesses from the city, residents from the convoy, yada, 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 to see, the circumstances surrounding Justin Trudeau invoking the emergency. I would love to testify. Oh, I would love to testify. And you know what the first thing I would say? You're all a bunch of pathological liars. Catherine McKinney, maybe that's why you blocked me, regurgitating misinformation about, oh my God, about the homeless shelter that had truckers come and demand meals and then racially insult security guards and assault homeless people. Hey, you know what? There's a reason, Catherine McKinney, why you admitted that, it wasn't Catherine McKinney, it was Mathieu Fleury, that you hadn't seen any police reports, that you don't know who, if anybody filed the charge, that you don't know anything, because it probably didn't happen. Oh, and then Catherine McKinney regurgitating that propaganda lie about Nazi flags all over. Oh, there were Nazi flags, swastikas, Confederate flags. You know that's a lie. All of you know that's a lie. There was, at best, one of each. There was one person with a swastika and one person with a Confederate flag. And the one with the swastika was told to leave and never came back. And there's still some dispute about what his message actually was. There are two diverging theories. One is that it was an absolute plant, so they can get their photo up and they can then say this protest is filled with Nazis and swastika flags. That's one idea. The other is that this guy was a bona fide Nazi and thought he would be welcome among the convoy protesters. The other theory, which is entirely legitimate and very plausible, is that this guy was carrying around a swastika flag to draw an analogy to the fact that this is how the Canadian government is acting. And then people told him, put it away. If that's your message, you're an idiot. And if it's not your message, you're an idiot. Pack up and leave. And I know the guy personally who told him to pack up and leave. He works for the PPC. I know the guy personally. I saw the video where he was saying, get out of here, put that flag away and leave. And that guy put the flag away and never came back. The Confederate flag? Oh yeah, because Canadians are all into the Confederacy. Idiots. And they regurgitate these two isolated incidents. In fact, they weren't even isolated. They were singular incidents. They repeat them and then add the word, there were flags, there were swastikas, there were Confederate flags, as if there was more than one, as if it was nothing more than a one-off idiot or a one-off idiot who didn't know how to make a message. But they come and they just, that's what they testify to. Oh, assaults. Protesters were getting in the face of residents saying, take those masks off. Lies, 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 damn lies. And I know why. I was there. People were wearing face masks so they wouldn't be recognized, so they wouldn't be outed, so they wouldn't get fired, lose their jobs, etc., etc. Nobody was shaming anyone for wearing a face mask. That, by the way, and it was -20. A lot of people wearing face masks just because it was damn cold. They're also known as neck warmers, scarves. But Catherine McKenney, Mathieu Fleury, good city councillor representatives spew the garbage, spew the lies, regurgitate it over and over. Oh, we went for night walks, but we were scared. Oh, I wasn't scared in the protest. I was scared in the residential periphery when I would walk home alone at night. Yeah, you know why? Because all of those homeless people and the drug addicts and the people that lurk around Byward Market and Wellington Street, the downtown core, they got displaced by the protesters and they were in the periphery. Oh, all of a sudden, people don't like homeless people hanging around when they're not isolated in one area that they don't have to frequent. But yeah, that's it. Lies, lies, and damn lies. Or as I like to call it now, lies, lies, and Emergencies Act inquiries. So yeah, I'd go down. We'll see if it happens. I don't know if it's too late. I suspect it's not, but who knows? Maybe I'm too much of a persona non grata to even get invited to there. But until Barnes gets in, there was one other video that I wanted to share with everyone. Not a man passing out as he skydives. I think that's fake. I think that video's fake anyhow. But no. It's something that's far more preposterous, absurd, insane. Here we go. First of all, Brooklyn Defiant Dad. I know that it's a big account and whatever. What did he say? He shared this screen grab. Accurate and cosigned. Let's read the meme, shall we? There's the old expression, the left can't meme. Oh, you guys see my messages. Well, that's embarrassing. It's a good thing I've got nothing to hide. Hold on one second. Let me close this down so you can see. Here, Nancy Pelosi wasn't hysterical or emotional on... Sorry, I got distracted. Nancy Pelosi wasn't hysterical or emotional during January 6th. She was cool and collected, determined to save our democracy. No plates or ketchup hurled. I don't get that. Strong, wise women leaders. We need more of them in the U.S. Are y'all familiar with the expression soft bigotry of low expectations? Well, we now have the soft, what's the word? Not misogyny is the opposite. Soft misogyny of low expectations. We look at some people, I say we as in the individual who drafted this, some people look at a woman and the first thing that comes to their mind is they're hysterical and they're emotional. And when they're not, we should compliment them for not being. Our regressive stereotypes of what we think a woman is. Nancy Pelosi wasn't hysterical or I got to tell you something. When I look at a woman or a political leader or anybody, I don't reflexively think that they must be hysterical or emotional because they're women. In fact, I don't even think that, period. And I got to tell you something. I've seen men behave hysterically and emotionally. I think that someone is hysterical and emotional when, regardless of sex, gender, creed, race, or religion, they behave in a hysterical or emotional manner. And I don't think that that's gender specific or even gender predominant. But apparently some people look at Nancy and they say, she's a woman. She must be hysterical and emotional. And therefore, when she doesn't act in a hysterical and emotional manner, I should compliment the woman for not being what I think the woman is. I think women are hysterical and emotional. And when they don't behave that way, I give them the man's clap. I you know, this little kid, you know, funny, a man complimenting a woman for not being hysterical or emotional. Why would anyone even have those thoughts of a woman in the first place, then feel the need to praise the woman for not succumbing to these traits? Damn typo. If they were not, in fact, a closet misogynist. But, what do we hear here? She said she was calm, she was cool and collected, determined to save our democracy. No plates or ketchup hurled. No. She was only talking about physically assaulting the president of the United States. Don't trust me. Trust Fancy Nancy.
Oh, he comes, I'm going to punch him out. This is my mom.
I would pay to see that.
I'm waiting for this, for trespassing on the Capitol grounds. I'm going to punch him out and I'm going to go to jail and I'm going to be happy.
Now, I don't know when this is from. Oh, this is from the January 6 hearings. It doesn't even matter when this is from. That's a calm, cool, and collected individual. I mean, she's definitely not hysterical or emotional. She's just rabidly violent and insane. And proud of it.
Oh, he comes, I'm going to punch him out. This is my
Punch him in
mom.
the face.
I'm waiting for this, for trespassing on the Capitol grounds.
Oh.
I'm going to punch him out and I'm going to go to jail and I'm going to be happy.
It's amazing. It's like, let me at him. It's the drunken bar fight where the guy's like, hold the little skinny dweebs. Like, let me at him. I'll beat that guy up if you just let me go and fight him. Oh my goodness. Yeah, but she's no, definitely not emotional or hysterical. Just a raging, a seemingly inebriated psychopath. Yep, violent and proud of it. But yeah, she's calm, cool, and collected. No ketchup hurl. Just threats of physical assault, and proud to go to jail because of it. All right. We got a good show tonight. I don't know. We'll see what Barnes brings by way of white pill, because some of the decisions out there, they're not the white pills. But before we get started, we are going to move it over to Rumble sooner than later. I'm going to bring up a super chat or two or three, which are flagged in the background. Section 230 is unconstitutional. Thus, all platforms will... Hold on. Section 230 is unconstitutional. Thus, all platforms will kill Alex Jones, David Fright, and Robert Barnes because they will be liable. Stephen, I have no idea what you mean, but is that a threat? I think you mean kill the channels. Section 230 is unconstitutional. Thus, all platforms will kill Alex Jones, David Fright, and Robert Barnes because they will be liable. Thank you for the super chat. There were two more in the house. Ian Hall, gotta say, Viva, your pronunciation makes me wonder if I've had too much to drink or if you are really saying certain words certain ways. Probably both. Keep up the good work. Ian Hall, thank you very much. Let's do this. And okay, we got that one also. So super chats. YouTube takes 30% of all the super chats. If you don't like that, and I can understand some people don't. Rumble, where we are currently streaming to a crowd of, let's see here, 7,721, 2-1. Fantastic. We'll be moving it over there sooner than later. On the menu tonight, let me just get back to my screen here. On the menu tonight, lots. When I say that there's black pills, John Stossel was suing Facebook and his third-party fact checker there for defamation because they said Stossel was factually incorrect, flagged his content, suppressed his content, redirected traffic to their own websites. The decision came down and dismissed on a motion to dismiss and an anti-slap Stossel's decision. And there's we're going to talk about the Alex Jones decision. Just a cool $1 billion to 16 plaintiffs. Where's the list? Let me get the list. Now, I see Barnes is in the house. Okay, and he's got a shirt on, which I'm going to ask what it means. Here we go. Robert, sir, how goes the battle?
Well, I don't give a damn about the whole state of Alabama, because I'm from Tennessee. Great win this week by the Tennessee Volunteers, upsetting one of the greatest games ever in the history of college football, 52-49. Go Vols. I got my celebratory cigar ready.
Robert, may I ask an obvious question? Did you have anything riding on that game?
Actually, I had a bet on Alabama. That's what you call an emotional check bet, right? So you bet on the other side so that if you have a disappointing outcome, at least you make money. And if you lose the money, you don't care because you care far more about the win.
Very good. Oh, here we go. I'll bring up one super chat before we get started here. Mr. Barnes, can you get Kyle Rittenhouse lawyers to use the Alex Jones rule in his suits? The news media will not give everything he needs to put the news media will not give everything he needs to put on his case. So by this rule, he can get a default judgment. Well, Robert, the problem is this. There's the Alex Jones rule, and now there's the new John Stossel rule, which was the Candace Owens rule. There's two sets of rules here. We're going to have to get to them in a bit. Okay, Robert, what's the book behind you? Because it looks like it's about international politics. No,
it's the book we are reviewing this month at vivabarneslaw.locals.com. The Emerging Republican Majority. We're through the Northeast and the South. We're going to cover the Midwest and the West before Election Day. And I'll wrap up. But it's a great book by Kevin Phillips. He wrote the text for it back in the mid-1960s when everybody thought his theories and premises were nuts, by the way. They thought there was a liberal democratic order coming in that was going to dominate the end of history in Fukuyama's terms. And he was saying, nah, the world's actually about to go in a completely different political direction. His predictions ended up deeply accurate. Brilliant analyst of widespread trends about the role of ancestry and religion and ethnic background and the role of, like, sometimes I'll get these people that will yip away about, oh, Barnes doesn't want to talk about the whites. It's all about the whites. And, you know, it's somebody that's race obsessed. And I was like, well, that's an idiot, because if you think the Yankees and the Italians vote alike in Connecticut, you don't know nothing about American politics. So it's a great book about tiny little differences, the differences between where German immigrants came from. Did they come from the Catholic section, the Protestant section, the East, the South, or the West? All will have voting differences that will actually show up on Election Day, November 8th.
And Robert, I'm going to go to our list, but we got a ton of stuff on the menu.
Oh, yeah, we got the Alex Jones trial, that outrageous verdict. We got the Nikola CEO who's going down to the Huskow. We got a free speech win on college campuses, a good one for Young Americans for Freedom. We got a city that's suing Peru in the international court about whether or not they've deliberately allowed toxic minerals, toxicity in their environment. Steve Wynn wins a big case against the Biden administration. The Robin Hood class action that we said would survive and that a bunch of naysayers on law Twitter said will go nowhere. We'll have a little update on that. We got SeaWorld, which decided to hire actual criminals to scare people for their Halloween exhibit, and it went a little too far. We have a big dormant commerce clause case that has broad scale potential influence. And if the oral argument is any indicator, the Supreme Court might try to punt instead of rule. We got Andy Warhol up at the Supreme Court. We got Amazon apparently likes to sell your kids suicide kits and knows about it, according to allegations filed against them.
That's the most. Look, I'm only going to be. I'm up to speed on about half of these. That Amazon, is it Amazon or yeah, it's Amazon.
Yeah, it's Amazon.
Saying eBay. It's the most shocking thing ever, and I don't think I'm sensitive. I think it's shocking. We'll
no doubt. We got a new antitrust law that might pass the Senate. We have Pfizer making certain admissions about their vaccines that seem to suggest they've been engaged in false advertising here in the United States, to the detriment and maybe the death of millions of people around the globe. Taylor Lorenz, amended complaint filed against her by Adriana Jacob by Harmeet Dillon, which I think has a above average chance, should survive if the court sticks to its original ruling. We have courts deciding they're going to start getting rid of legislators they don't like by misusing and abusing the 14th Amendment clause. We have a judge who decided he was going to jail a juror over not wearing a mask. We have Trump's notorious response to the January 6th committee to subpoena him. We have a great court ruling identified by Glenn Reynolds, the great Glenn Reynolds, who was out of the Sixth Circuit Court of Appeals that says, no, the government cannot steal your house for a tax debt. What the states were doing was, let's say you owed 10 grand, and they would take your $300,000 house and take all of it and give none of it to you by declaring you forfeited your interest in the property by owing tax. No, that's an illegal taking, unconstitutional taking. And then, of course, we have the John Stossel case as well.
So we'll start with the Alex Jones just because it's the news of the week. The trial went exactly the way everyone, I guess, wanted it to. But Robert, everybody knows what happened. $965 million in damages.
Just to begin with, they're going to add more. It's going to be about $1.5 billion when they're done.
Yeah, I think. Pat has said it's going to be maybe $2 to $2.5 billion because they're going to have punitive legal fees, etc. Biggest award was $120 million to Robbie Parker, $90 million to the FBI agent who had no family members get killed in the incident. The worst that was said about him was that he was an actor, that he might not have been an FBI agent. He didn't wear the right bat, whatever. Harassment associated with that, $90 million, and it goes down to $2.8 million. Some are saying the trial went exactly the way the judge wanted it. Others are saying the judge has to be a plant, has to be there for Alex Jones because this is so absurd. It's so preposterous. It cannot but get overturned on appeal. Robert, I mean, the triple fakey false flag, one thing. This is over the top, is it not? Or is it?
It's utterly absurd. It's utterly absurd. It is the biggest verdict in the history of libel lawsuits by a ratio of about 100x. So it's about 100 times bigger than any kind of verdict like this ever. And again, most of the people who recovered damages, all but one, I believe, that recovered damages in this case, Alex Jones never talked about ever, including the FBI guy who didn't lose anybody at Sandy Hook, who admitted on the stand, we covered it live, admitted on the stand that he didn't know he had never seen Alex Jones identify him by photo, by image, by name, nothing. And yet he's allowed $90 million.
I think the worst thing that the FBI agent testified to and admitted to was that the harassment actually started even before Alex Jones covered the story.
Completely. And that the FBI investigated it and decided there were no criminal charges to be brought, which has to raise a question about exactly how accurate he was in that information relayed. If people were really harassing an FBI agent to the degree of death threats, things like that, that's a crime. They would have been investigated. They were investigated, apparently, and they would have been prosecuted. They weren't, would suggest that something wasn't quite up. So it's a laughably absurd verdict. It's the clown verdict to a clown trial. And it should surprise no one, given what a complete crock that trial was. The only kind of person it could shock, or not shock, is, say, someone who purports to be an independent, big trial, free speech advocate on YouTube and is like, I'm not sure if it's $1 billion. I'm not sure. When people had raised questions, including on our locals board, why I was particularly critical of certain law tubers who chose not to cover this trial, and also showed in their other behavior that they're not reliable, not trustworthy people. My view is that if you're going to be an independent commentator, your only utility is to actually be independent. If you're going to be a free speech advocate, and a big trial covered person, you can't ignore the Alex Jones trial and use willful blindness as your excuse for, I'm not sure if $1 billion is too much or not. That's the kind of person that's like, should I be loyal to someone who gave me my whole channel or not? And so those kind of people, by just random tidbit, don't complain about people asking about who your husband works for if you say that because you're a military spouse, we can't question your commitment to free speech. Also, don't complain about people asking for photos if you've got 4 photos behind you in the video.
I'll tell you one thing. We're not set aside the YouTube drama, Robert. I think everybody set aside the YouTube drama. There were a lot of people who were not following it and equivocating, and also just if you didn't follow it, it would have been a weird thing. But then to express an opinion is problematic. It's when people say, I didn't follow it, no opinion whatsoever. I wonder if David French followed it because he had some strong opinions. This is what happens when you defame people, yada, yada, totally bypassing the fact that there was no trial on the merits and the trial on the quantum. To say Jones had 2 hands tied behind his back would be an understatement of the millennia. But this is the issue that also people don't really understand. It's $965 million compensatory damages, not punitive, not, I don't know what other types of damages there could be, but not punitive. So Connecticut law, they had no emotional expert
that I know of to testify to any emotional damages. They had no reputational damages from an expert that I saw. So again, this is in many states, you wouldn't even be allowed to argue emotional distress if you don't have emotional expert proof. And so the everything about it was absurd. And so my reason for calling out certain commentators who have failed to cover this case is like Legal Bites completely failed to cover this case in a meaningful way. Don't pretend you're a free speech advocate because you're not. I call her out to call everybody else out that is taking a neutral Pontius Pilate type position on this. This is as big. You cannot claim to be a free speech advocate and say this verdict is okay. You just can't. There's no honest, credible coverage of this case or review of this case. The verdict itself should scream that out to you, that this is a core attack on free speech in America. This is, we can write billion-dollar checks to people based on speech offending them. I mean that's what Alex Jones is being held responsible for. There was no evidence Alex Jones stalked anybody, harassed anybody, doxed, none of that. The only evidence was Alex Jones spoke out. And because of his speech, we're blaming him for everything else that happened. But let's be clear, they're blaming him for his speech. And it's not a traditional defamation claim at all. Doesn't fit the constitutional defamation at all. So to transition into what appeal rights he has, so his appeal, the first and core appeal, is the First Amendment to the United States Constitution. State courts cannot weaponize state tort law to punish speech. This was the point of New York Times versus Sullivan and its successor cases, including Westboro Baptist. That's been clear over and over again. So it doesn't matter how you denominate it. Much of the damages, contrary to David French's position, was not actually defamation. It was consumer product damages, even though they weren't alleging any injury from the consumer product. I mean, that's how nuts. They're trying to take all these other areas of law and find new creative ways to punish dissident speech. And to be clear, the legal theory they had in this case is that if a major incident occurs, that there's now a legally protected safe space, that you cannot comment on that topic if it will upset and offend anybody within that zone of danger, within that legally protected safe space. Even if you never talk about them. Doesn't matter if you talk about them. Doesn't matter. The constitutional requirement of colloquium is the second thing this violates. So the first constitutional violation is they're simply punishing speech using state tort power, which they legally cannot do. Secondly, if to be outside of that, it has to be a classic case of defamation, and that requires that there be a factually false statement about a specifically identified individual that then causes reputational injury. That wasn't met here, and they ignored that. And the courts have been clear they're ignoring that. They're rewriting the law to say that the constitutional requirement of colloquium is what it's called. People can go back and read the New York Times versus Sullivan case. The second part, everybody talks about the actual malice standard. That's only part one of that case. Part two of that case is they said constitutionally there's a requirement of colloquium, which means the statement has to be about that person specifically. So they said in that case, it was clear that that individual was within a zone of danger, within a legally protected space, because the statements were made about the police hierarchy, and he was only one of a small group of people that was within that police hierarchy. But Supreme Court said, nope, that's not enough. You have to specifically identify the individual. Now, you can identify an individual by pointing out their photo. You can identify an individual if they're in such a small group that there's no doubt it's about that person. So let me give an example. Let's say somebody says, LawTube is filled with a bunch of loser grifters that don't know anything, etc. Can Viva sue? No, there's too many LawTubers. But what if they said, Viva and Barnes are a bunch are lied about, Well, then either one of us can sue because that's a specifically small enough group, right? Or the 5 people on the Ricada channel on day X did something false. Well, that's a small enough group. The old case is New York. The case came out of New York. 2 different lies were told about Macy's employees. One lie was about a group of Macy's employees that only had less than 25 workers in it. The other part had a department that had more than 100. The court said, more than 100? No way you can sue. Less than 20? Okay, we can see that. Problem here is the number of people within the legally protected Sandy Hook safe space, again, including FBI agents, was thousands of people. That because they claimed that you didn't have to be someone who died. You just had to know someone who died. You didn't even have to know someone who died. You just had to have some connection to it. just be an agent there, investigated it, talked about it. Well, that's thousands and thousands of people. That has never been allowed in the history of libel law because it violates the constitutional requirement of colloquium. So that's his second grounds to object to all of this. The other grounds include complete denial of his right to trial by jury, misuse of what's called the death penalty default judgment, which stripped him of his right to trial by jury, and due process of law. Then you have violations of misapplying the consumer product statute to something that doesn't concern consumer products. Then you have all of the evidentiary violations that occurred in this case. As Norm Pattis said, in studying all the cases he studied and being part of all the cases he's been part of, no case in Connecticut has ever done what this court did at any level. And this included ridiculous interpretations of the rules of evidence. And that's why I call out, if you're going to purport to be an independent legal commentator defending free speech, you lose all credibility with me when you don't cover the Alex Jones trial. You lose what little tiny bit might be left when you're not sure if $1 billion verdict is absurd. I don't take any legal commentator anywhere seriously that thinks $1 billion verdict is just fine or is not sure if it's bad. It's laughably absurd, and everybody knows it.
People have to appreciate it's compensatory damages. So they had to show the damages for which they're being compensated. $90 million for the FBI
With
agent.
no expert about emotional harm, no expert about reputational harm. I mean, it's unheard of. This is utterly unheard of, utterly unprecedented. You won't find another verdict like this anywhere in the history of the world. It's 100 times larger, the average. I can tell you from focus groups and jurors, it's about 100,000 times larger than the average jury verdict was given when they heard both sides. So that's why they had to rig this trial. This was a show trial. It was with a clown judge, which resulted in a clown verdict. And it's a disgrace to the rule of law. But here's the hurdle. All the law is on Alex Jones' side, but few of the judges are. So unless a lot of noise is raised in the court of public opinion, the Connecticut Court of Appeals, the Connecticut Supreme Court, the Austin Court of Appeals will do nothing about this. They've already eviscerated his rights in prior cases. They've created, like everybody said, hey, can't we use the Alex Jones precedent to go after all these other people? I guarantee you they'll suddenly rediscover the law. This will all be Alex Jones exceptions to the rules of evidence, to the rules of due process, to the rule of trial by jury, to the right of freedom of speech. And if anybody had any doubt what the purpose of this, and remember, folks out there, over 90% of the people who suffered a traumatic loss at Sandy Hook have never blamed Alex Jones, have never sued Alex Jones, never sued the gun company. This is a tiny, politically active group. And if you had any doubt about that, and by the way, Norm Pattis was denied the right to cross-examine them on this political bias, wasn't even allowed to say the words Hillary Clinton in trial when she was the reason for this whole lawfare being instigated and initiated and originated in the first place. But if you had any doubt about it, just like the plaintiff's lawyer in Texas, plaintiff's lawyer walks out, and is he looking at collecting money? No. He says, hey, everybody out there, stop supporting Alex Jones. Don't give any more money to InfoWars. Don't give any money to Alex Jones. Now, why would you do that if your point was to recover for real damages of your clients? Never seen a plaintiff's lawyer do that in my life. Why? Because this whole case was about suppressing, silencing, censoring, shaming an independent, populist, dissident voice that they hate.
Okay, the grounds of appeal. Let's just say, as far as the colloquium, or we don't know who was being referred to in the statements. If I put them on a hierarchy, I would put that one a little lower because there are only so many parents of Sandy Hook. It's true down to the extent that
it, right? Then the FBI guys got to be
well.
Out.
That's where they open.
Siblings. I mean, do you include the siblings or not? The issue is there's no doubt, there's no dispute factually that he didn't identify almost any of these people by
with
name.
The exception of Robbie Parker, who got the biggest award of $120 million.
Correct, and only in one context because they're suing him for a bunch of other statements. 99% of his statements didn't concern Robbie Parker. So and then in the Texas case, he never referred to either one of those. So historically, it's been, if you don't refer to them, it has to be they have to be of such a small group. The parents don't even count because the limit has usually been 20 to 25. And here's the way to think of it. The idea is that the reference is so obvious to that person, even because they're of such a small group, that everybody knows who you're talking about. The problem here is they didn't even know who these parents were. They didn't even know who these people were. The excuse of the Texas Court of Appeals in Austin was, well, maybe they could find him on the internet. And it's like, hold on a second. That's never been our standard, that you can look up and research and independently investigate who the statement might possibly refer to. That's never been the claim. So that the constitutional requirement of colloquium is is his strongest argument from it, because it's a federal issue. It's a constitutional issue. It's an issue that the U.S. Supreme Court can get involved in. A lot of the other claims are specific to Texas or Connecticut law.
Well, my issue, Robert, with the colloquium is that as a matter of fact, will be relatively easy for them to say, well, there were only there were 20 some odd victims. Therefore, when he says they were crisis actors, he can only be referring to the parents of 20 some
Or
odd people.
siblings. And that's well over the 25 max historically.
Of those who
parents
gave
are well over the 25 max. That's
okay.
the issue. And so that's why they knew from day one they had a major hurdle. That how do you sue for defamation when you're not referenced and when you're a part of a group that's too big historically? So I'll give you an example. I had a sufficiently small number of Covington kids that were specifically identified by photo. Could I have sued for all 80 Covington kids that were there that day? No. And everybody agreed no. It was only the people that were identified by image, because that's how. Remember the Kentucky Fried Chicken case? There are only like 25, 30 Kentucky Fried Chickens they could have been referring to, but that 25 has been the cap, and often they've gone below that. And the reason they've gone below that is it's got to be obvious the group is so small that you can't help but think, oh, that's a reference to that person. And the problem is that just wasn't there, because not only that, these people weren't publicly known or identified as well. So, if you'd put them up by photo, if you other way, then there's a different argument. But that wasn't the case here, and that was the problem. So you have the Robbie Parker case, which could be separated out, but then it should be only that statement about Robbie Parker, not all the statements that are just about Sandy Hook in general. And none of it justifies compensatory damages. This makes our American civil court system look like a joke.
The one thing is $1 billion, yeah, divided among 16 plaintiffs. Okay, so it's only 120 million for defamation and intention, IIED. Still preposterous. Robert, what I love also, though, is the people out there who are, clamoring. Stephen Goldstein, Jones would not provide discovery, yada, yada. David and Robert are in the same boat. They will not follow discovery. Well, Stephen, following your last thread of a message, I hope you have $1 billion. Unless you think that, some people get to say whatever they want and others don't. And also,
anybody who watched the trial could see that the default death penalty sanction was ludicrous. Because the plaintiffs had all the evidence they ever needed. In fact, they had more evidence. And I'll say this again, Alex Jones produced more discovery than any media defendant in the history of libel law.
But someone's going to say,
find an analogous case where somebody was issued a death penalty default judgment. I've challenged lawyers to do it. They haven't been able to find one in the history of America.
Well, that part, I don't think it's a matter of fact. If anybody finds a decision where a media defendant was death penaltied default verdict for not turning over discovery documents, fine. Robert, what people will say, and it's the rebuttal, you could turn over 10,000 documents. If you don't turn over one, and it's the critical one, I still don't think
that's never grounds for default. It's not a ground for the court to strip you of your right to trial by jury. They have to find extraordinary claims. It has to be default death penalty sanction is considered for people who are not participating in the proceedings. Number one. No, so clearly that didn't apply here. Alex Jones sat for hours and hours and hours and hours and hours of deposition testimony.
It is true that they deposed him even after the default verdict.
Yeah, exactly. Multiple times. I mean, so it was just absurd. So that's part one. Part two is there has to be a strict connection and no lesser remedy. There was no strict connection. What was it they didn't have? They didn't identify anything at trial they didn't have. They knew how much money he made, how much gross revenue came into InfoWars by date and time. So what they did is for those that don't know, how they got to default judgment was, give us the evidence that you're guilty. No, I'm not guilty. I'm innocent. Aha! You have denied us the evidence that you're guilty. We hereby declare you guilty by default. That's what happened. That's what was always going to happen, because their fake case, supposedly about fake news, was in fact a fake case. They were blaming Alex Jones for things he was not responsible or accountable for. And the goal is to weaponize the legal system to suppress, censor independent dissident speech. And they will never apply this Alex Jones precedent to anybody on their side of the political aisle ever, but they may apply it to others on the Alex Jones side. And people, and I think the other disturbing thing about this, Martyr made this point on Twitter. And I increasingly agree. This idolatry of victimhood that this case also celebrated, which was, hey, I suffer a terrible tragedy. Now I get to tell you what you can do. Now I get to line my pockets with your money. I'm morally superior now. You can't question my case. You can't question my judgment. You can't question my action. I'm the king victim. This is a dangerous ideology, a dangerous idolatry that undermines society's core values, and we should reject it outright.
Just reading some of the chat now, Robert. Okay, so setting aside the legal standard of appeal on that one question, colloquium, Eighth Amendment violations, is that even conceivable in this context? I mean,
not so much. It wasn't technically a fine; it was a civil judgment. So it's still more of a First Amendment issue. It's the misapplication of these laws to reach speech that violate the First Amendment. So the broad one is, the first one is colloquium. The second one is a broad category that this is the state courts weaponizing state torts to punish speech in violation of the First Amendment in a way that is not carved out, that there's no exception to. And so that's the big constitutional claims. There is also the right to trial by jury and the right to due process of law.
Is that not the strongest grounds for appeal? Like one of the reasons, at least in Quebec, judges don't like dismissing cases until they go to the merits is it makes it so much easier to appeal. They say, I never even got to a hearing on the merits. This judge, default verdict and stripped. Is that not the strongest grounds for appeal? Like they would have to show clear and unequivocal evidence that would justify the judge imposing that sanction.
Because it requires a deep dive factually, it tends to be a less appealing appellate issue. Mm-hmm. So the misuse and abuse of default power is a major problem here, but the courts are less likely to jump in as they are on the First Amendment issue. Because the size and scale of the verdict is embarrassing to the judiciary. Because this makes it look like our American legal system is a complete crock. Nobody thinks anybody suffered $100 million in damages because of what Alex Jones said. That requires ludicrous logic. And to give an idea, less than 1 out of 10,000 jurors were of that inclination. They managed to stack and rig the case in such a way that they could induce that outcome. But so I think those aspects are the real constitutionally attractive issues for the courts to be concerned about. What are the limits? Because there are no limits put here, and our traditional constitutional limits were eviscerated. He also has the federal constitutional issues of trial by jury and due process of law, also state constitutional issues of trial by jury and a range of other issues. The statute of limitations was not enforced here. That's both a due process issue and a statutory issue. And then there's all the violations of the rules of evidence, a range of violations on jury instructions, if there was a rule to be violated, the judges in these cases violated them. They were obsessed with a shambolic verdict against Alex Jones that would scare and terrorize his supporters from ever supporting him again, and and anybody like him from rising up. That's what the case was about. It was open and overt. It was not about really about compensation. In his opening statement, the plaintiff's lawyer made clear what he was there for: give a big enough verdict so that Alex Jones can never be on the air again. That was the goal.
People are asking this, is Alex going to be able to survive this? Will it deter people from? I mean, the thing is, the money that he makes, it's not from super chats, and I guess it's not so much from donations. So it's not like people are going to say, I'm going to stop donating, because that's not primarily where it comes from. Product sales and whatever, and people are still going to buy it because they're still going to get a product for it. Have you noticed any deterrence on a fan base to say any money we give him is now going to go to pay these families, so let's stop supporting Alex, to some extent?
Yeah, he's fought back against that directly, because any money that comes into InfoWars just keeps InfoWars on the air. If there's any excess profits, then the families can profit from that excess profits, but there hasn't been a lot of excess profits. So so his goal is just to keep InfoWars on the air, any way, shape, or form, while he fights this through the appellate courts and the court of public opinion. And I think they were hopeful the verdict would be so big that it would shut down InfoWars. That's not going to happen. In fact, the irony is this: Jones would have retired several years ago, but for this case. He was kind of exhausted. He'd done a lot of work over a quarter century, achieved a lot, and he was ready to just to say, hey, I've done great work. Good luck, everybody. But because they tried to silence him, because they tried to censor him, because they tried to shame his audience for supporting him, is why now he'll never go away. And they're right. In the end of the day, Alex Jones is uncancelable, and they'll discover that the hard way.
Let's see this here. It's those colloidal silver junkies supporting him. By the way, great stuff to keep you not sick. No
I mean,
medical
that's why we use
advice.
silverware. That's why we use silver. I mean, silver's been around for centuries as something that's good for you.
Yes,
right?
but you know, Robert, you eat off silverware. You don't eat silverware. So just so that everyone, there's no medical advice here. But hold on, I had one more question about Alex Jones. So compensatory damages, no limits. Not that it makes a difference on this amount. Is there a cap on punitive damages under Connecticut? Like it's a factor of the compensatory damages?
There is in certain cases. There is not in this bogus consumer fraud case they brought. So we'll see how much of a joke the judge is. Does she issue some ludicrous punitive damages award to show how much she was in on this fraud on the American people? And but I think a lot of people thought maybe I was exaggerating or overstating the case. Now they realize I was, if anything, understating the case. That this case is a direct threat on free speech, a direct threat on dissident opinion, the continued weaponization of our legal system to suppress and oppress voices. It's not new. During the civil rights era, American courts in the South did everything they could to shut up the civil rights movement. That was why New York Times versus Sullivan went up. They went after Westboro Baptist because they didn't like their opinions. That got a crazy $77 million verdict that got the Supreme Court's attention to being like, no more of this. So the size and scale and scope of the verdict is such a big warning sign. You saw people like MIA and others be like, hold on a second. This seems a little nuts.
Not that I'm not citing people on the left as authority. I'm just citing people who are on the far left, Vaush, laughing his ass off. It's hilarious in the insanity of a $1 billion judgment, even if it's divided among 16 plaintiffs. Everybody knows that it's absurd. It's just that some people who are present in the chat love this injustice, so they can use it to threaten other people to shut them up. So, I hope you have $1 billion. That's the new standard. $120 million. Anybody want to, question or ask questions about the Armenian genocide? $100 million. Something that hurts people's feelings who have suffered from a tragedy. $100 million. That's the new standard. And people love it because they think that the rules are only going to apply to to them to punish their ideological adversaries, and they can continue calling Trump a Nazi, a rapist, and whatever. And that's it. That's how it's going to work. Anything else on Alex Jones before we mosey on over, people, to the Rumble side?
Because this is probably good to transition to Rumble. The only people that are responsible for billions of dollars of damages is a certain drug company promoting a certain product.
Well, that wasn't the segue I was going to go for, but that's a good one. Everybody, hold on. Did I miss a few super chats? What happened? This is what happened to Remington default judgment, which is why they settled their suit. I don't know. I still don't understand why the insurance companies agreed to pay the maximum as opposed to litigating for potentially less. Razorfist released a rant defending Alex Jones. He says that this will be used to go against opposing voices. Obviously, they're doing it already on social media. It's become a meme. I hope you have $1 billion to say something like that. There has to be a way to sanction the judge. She has to face some consequences. Some way has to be found. She can only be impeached, Robert. I mean, that's the only.
Oh yeah, Connecticut's a corrupt state, so don't expect anything there. Razorfist gave a righteous rant. He mentioned that topic briefly as part of it too, by the way.
All right, now we're going to remove it from YouTube. Bring it over to the Rumbles, and I'll post the entire stream tomorrow on YouTube. I'm 1 day behind, so I've got to post yesterday's stream today after this. Removing 3, 2,